Yeah.
This is how I figured out that my watch battery is dead. So I was like, oh, I'll just look at my watch. Oh, no,
all right. I think we are going to get started. So thank you for coming to join us this evening. It's lovely outside. It's nicer in here. So thanks for making this an enjoyable evening. We're going to talk to you today about executor and power of attorney roles. So these are pretty fundamental pieces of how our Canadian legal system works and succession rights and succession planning. So two key roles. Our speakers tonight, I'll get there in a minute. First of all, I was going to tell you a little bit about, we're from Fulton & Company, so the law firm in Kamloops here. And we are long and well established in this region. So we've been around since 1885, even before the town and the city of Kamloops was even incorporated. Initially, we were on the 100 block of Victoria Street. We think this might have been what the building was looking like back in those days. And some of our favorite trivia is that we had the phone number 6 for many, many years until the 1950s. So if you wanted to reach our firm, you would just dial 6. And I suppose before that was 5 would be like the constable, and 4 would be the hospital, and 3 would be, who knows, who got the first lucky number 1, we don't know. But we had number 6 till 1956. And we have had quite a lot of establishment in the Kamloops history in the region. We have the Fulton Field, we have buildings on the Heritage Walking Tour. So we're old, but we embrace innovation. We also are a large firm for within the region of the Kamloops interior. So we call ourselves a mid-sized firm. We have over 25 lawyers, 70 staff in town, and we have a Vancouver office as well. So we focus our practices serving all types of clients, institutions, banks, financial institutions, local governments, and individuals, business owners, and people such as yourselves. And that's where we're going to talk tonight. So this is in relation to law that applies to individuals. Every single one of us, this will be relevant for, and relevant for our friends and family members. So that's why we like to come out and share this information, because it's quite pertinent to most, if not every one of us. Talking to you tonight, we have 3 presenters tonight. We're all lawyers at Fulton, and we all practice in the wills and estates realm. So my name is Leah Card. I'm the chair of our group at Fulton, and I've been with the firm for 20 years practicing just about exclusively in wills and estates and trust law. We also have Tyson McNeil, also a partner at Fulton, and Tyson focuses in litigation, so dispute resolution is his bailiwick. When the well-planned estates or trust arrangements go awry, then Tyson will be able to step in with some courtroom and resolution skills in his back pocket. And also presenting tonight is our associate lawyer, Taylor Bashand, and she works with both of us, so she gets both sides of the coin, helping people plan and execute their plans, and then also representing executors or powers of attorney or beneficiaries if things go a little bit off the rails. So thanks for joining us. We are going to talk tonight, as we've said, about power of attorney. We'll start there, and then we're going to move next into the executor role.
All right, as Leah has introduced, I'm Taylor, here to talk to you about powers of attorney. We'll start by talking about powers of attorney, since it comes first on the personal planning timeline, because you make a power of attorney while you're still alive. Wills and estates lawyers may not have a reputation for being funny. We're trying our best. So this comic represents a reality we see fairly often. A person's been appointed as a power of attorney, and they think it's a license to do whatever they want, and obviously it is not. So we're going to unpack what a power of attorney is, and why you want to name somebody responsible to act on your behalf. So what is a power of attorney? Let's imagine that your friend or your loved one, someone who we'll call the donor, has bestowed upon you one of the most esteemed badges of trust they've appointed you as their attorney. I'm going to use these two terms throughout this presentation: donor for the person who's giving the power of attorney, and attorney for the person who's being appointed and is exercising the power. So being named as attorney means that the donor has entrusted you to act on their behalf for all financial and legal matters during their lifetime. Most often, the intention is that they would help you manage your affairs in the event you become incapable of doing so on your own. This is important because a valid power of attorney can only be made by somebody who has the mental capacity to make one. The question of capacity can be complicated because there's medical definitions of capacity, there's legal definitions, and different levels of capacity are required for different situations. In order to make a power of attorney, you have to understand what property you own and the approximate value, any obligations you might owe to dependents, the kinds of powers that an attorney will be able to exercise, the risks that come with appointing an attorney. So your asset value might decline under their management, they might misuse the power of attorney, and you need to understand that you can revoke that. This is important because if you've been appointed as attorney and you have doubts about whether the donor had capacity when they made it, you should seek legal advice before acting under that document, because acting under a suspected invalid document could put you at risk for liability. And a quick sidebar about why it's important to make a power of attorney while you still have capacity. If someone loses capacity before appointing an attorney and they need assistance managing their affairs, a difficult situation arises where someone, maybe a family member, possibly even the public guardian and trustee, will need to apply to the court to seek an adult guardianship order. That's an onerous and expensive process, and it doesn't leave any room for the incapable adult to continue managing their own affairs in any capacity. So that can be avoided with some proper planning. But back to our discussion about what acting as a power of attorney typically requires. Okay, so what does a power of attorney actually do? So with great power comes great responsibility. The law recognizes that donors are in a particularly vulnerable position by giving an attorney so much power over their affairs. So attorneys are held to an extremely high standard. As an attorney, you're considered a fiduciary, which comes with the expectation that you'll act honestly and in utmost good faith, that you'll exercise the care, diligence, and skill of a reasonably prudent person. So if you're someone who's lackadaisical about their own finances and you've been appointed power of attorney, you'll have to up your game because you'll have to do a better job managing the donor's affairs than you would your own. So what do you need to do as an attorney? You need to ensure that the donor's personal and healthcare needs are met as your first priority. This is more important than preserving the donor's estate for future beneficiaries. You need to make prudent choices when managing the donor's assets. That means you would need to steer clear of unduly risky or uninformed investment choices. You have to foster the independence of the donor. So do your best to include them in your decision making. Part of acting in a donor's best interest is to help maintain their dignity and autonomy to the greatest extent possible. Unless it's necessary to perform your duties, you need to avoid selling or giving away assets that are specifically mentioned in the donor's will. Attorneys are usually able to review the will, and they can look to see that they're not accidentally undermining the donor's intentions. You have to keep the donor's personal effects and household possessions available for their use and enjoyment. An example is in my grandfather's final years, he took all the good china out of the cabinet and used it daily. So it was getting worn, but it's not unreasonable for someone to use dishes for their intended purpose, so let him do it. It's critical for donors to, or pardon me, attorneys to maintain records of all of their actions. No. So attorneys have to keep records of all of their actions. Attorneys can be called upon to disclose their records to interested parties, a process called accounting. And in the event you are called upon to defend actions you took as attorney, having a detailed record of your work is invaluable. Lastly, not on this slide, but overarching a few of these points is that an attorney should be taking into account a donor's wishes and beliefs when making decisions, provided that these wishes are expressed while the donor still has capacity. Again, if a donor's capacity is uncertain and you're concerned that they're being pushed into something, you have to act to safeguard their interests. And in that situation, we'd suggest seeking legal advice. So what are the limits on what an attorney can do? The power given to an attorney is not unlimited. There are some restraints imposed by law. You must not commingle or combine any of the donor's assets with your own assets. Assets have to be kept completely separate. You cannot change designated beneficiaries on assets like insurance policies, registered investment accounts like TFSAs or RSPs. You can't make a new will for the donor or change their existing will. And the general rule, unless it's expressly addressed in the power of attorney document, is that there's limits on the kinds of gifts attorneys can make on behalf of the donor. It's usually a maximum of $5,000, and it has to be a kind of gift they would have ordinarily made. So if grandma was putting $5 in all the kids' birthday cards, you can't get generous on her behalf. The same goes for charitable donations. And there's also gifts on, or restraints on gifting to yourself as well as attorney. You can't give gifts to yourself. You also can't pay yourself a wage or help yourself to the donor's assets as compensation for your work unless that power of attorney document specifically allows for it. So the takeaway is that you have to read that power of attorney document very closely, because on top of the general laws that apply, there may be specific restrictions within the document or greater allowances in that document that may augment your scope of authority. So if you have been appointed and you're wondering what it means to accept it, whether you have to accept it, even if a donor signs a power of attorney naming you as attorney, your appointment only takes effect if you also sign that document. By signing it, you accept the appointment. So common practice is for the donor to sign the document and then put it in safekeeping until they need help managing their affairs. That means that even if you've been named in the document, you don't have to accept the appointment. You may not want to take on the role. It can be a challenging position, especially if there are other interested parties who don't get along or if there's complicated dynamics there. If you decide to decline, you simply don't sign the document accepting the appointment. If you have already signed and you want to resign, we'd recommend talking to a lawyer about what that requires. Now, I'll make another note too about how long it lasts for before we get into our hypothetical Fred. The power of attorney is only valid while the donor is still alive. If the donor dies, the power of attorney is no longer of any force or effect. At that point, it's the representative, the personal representative of the estate that takes over, the executor. If a spousal relationship comes to an end, the default rule is that the power of attorney appointment comes to an end as well. It would also end if the donor revokes the power of attorney, which they can do as long as they have capacity. Okay, we're going to turn to our hypothetical Fred and see what we've learned. So Fred has dementia. Doctors have given him 10 years. His wife has predeceased him. So he's got 4 daughters, and he's appointed one of his daughters, Susan, as his power of attorney. So Fred's living in a care facility. He's renting out his house, and Susan is collecting the rent money for him, and she's depositing it directly into her dad's account. Susan has seen Fred's will, and it's divided equally between the 4 daughters. So Fred's daughters get together and do some strategizing. Dad's spending has gone down to almost nothing in the care facility, and they think maybe Susan could get a few steps ahead in the estate planning and make some of these gifts that their dad is intending to make now. They suspect maybe Susan could add the daughters to title of the home that's being rented out and put their names on the bank account. This way, they think they could avoid probate, and it would make everything simple when dad passes away, right? The daughters have all said, if dad ever needed anything, we would be there for him. Is this the smart thing for Susan to do? No, it's not. So if Susan were to put them on title to real estate, she would be directly contravening the Power of Attorney Act by giving a gift. And it's also against the Property Law Act, which doesn't allow attorneys to make gifts of land unless it's specifically provided for in that power of attorney. So presumably the Land Title Office would not let her carry that out. And adding the kids to the joint bank account, again, this would be considered gifting and mixing assets, which is also not permitted. So you might ask, well, the 4 daughters, they're meant to share it equally. They're all in agreement. Who's going to find out? Susan could be reported to the public guardian and trustee by anyone who gets wind of their little scheme. It could be someone at the bank, a nurse, a social worker. For those not familiar, the public guardian and trustee is a government entity tasked with protecting the legal and financial interests of children and adults who need help with decision making. As to why she could be reported? Yeah, so with her, she would be the only one who had the capacity to sign on his behalf to make those gifts. If he's lost capacity, he wouldn't be able to add the kids to title or add them onto the bank account. So she would be the one in the position to control his assets on his behalf. If he did that while he still had capacity, it would be fine with an asterisk. Not illegal, no. Perhaps not the best estate plan, but every situation is different. So, but yes, as power of attorney, if she has been doing these things, she can be reported to the public guardian and trustee, this body that looks out for individuals who can't make decisions for themselves. If she is reported to the PGT, they can investigate and they could sue on Fred's behalf. Other parties may also have standing to sue after Fred's passing. For example, if one of the 4 daughters passes away and let's say their son is their beneficiary and this joint tenancy scheme means that the deceased daughter's estate doesn't receive anything, she can sue on behalf of mom's estate to try to get those assets back in. So while giving someone power of attorney comes with risks, there are legal ramifications if an attorney misuses their power. And this can be brought by the attorney while they're still capable or other interested parties, including future beneficiaries. And what happens if an attorney is sued for misusing their power? They might be required to account for their actions, disclose all those records of all the work that they've done. They might need to restore assets that they have improperly taken or gifted. And they could pay damages, including punitive damages, which are damages meant to punish someone who's acted particularly badly. And they could be required to cover legal costs for the party seeking relief. So that concludes the section on power of attorney. I will hand it over to Leah to start talking about executors. Thank you.
Okay, thank you. We do want to invite questions, so we'll just ask you to hold your questions till the end and we'll do a Q&A. We can stick around for that. That's great. Okay, so second in time, first it's the role of the power of attorney, and then when the person passes away, it's now the executor's job and they take over with the responsibilities. This is another abysmal comic. We really need like AI to generate something with a little bit more flair for us, I think. So the executor, I mean, I'm sure you're pretty familiar about what the executor is, right? It's their role to take over the administration of the estate and to carry out the terms of the will. Key characteristics of a fantastic executor are somebody who is comfortable with a certain level of conflict. Conflict resolution comes up frequently if there maybe are some different interpersonal relationships there among the beneficiaries and the deceased, what have you. So things can get sort of old wrongs get brought forward frequently in estates. Knowledge generally about wills, estates, and tax can be an asset, and primarily a real good head for detail and being able to just manage multiple tasks and multiple balls in the air at the same time until the job is done. So to know that you're the executor, maybe you were informed when the person made their will, but maybe not. There's no requirement to get your pre-authorization before appointing you as an executor. So you may not know. You might have a copy of that will in your possession. You may have heard about it. You think there's a will out there, but nobody has a copy. So one of the jobs of the executor, if you think you are the executor, is to do your best to get your hands on the will. And so you need to look around and you need to follow those breadcrumbs and look through the deceased's personal paperwork, ask around their financial advisor, their accountant, phone the law firms that you think they maybe had dealt with in the past. And you can do a search in the wills registry in Victoria. If I made a will, it may be valid even though I have never registered it in Victoria. So the registration in Victoria is a nice to have, but it's not an essential. So just because the registry in Victoria has no will there, or a very old will, doesn't mean that there's nothing newer. So you really do have to turn over every last stone and try to get your hands on that original will. A copy is not sufficient unless it's officially approved by the court in a separate court hearing. So the presumption is that if an original is gone, it's presumed that the will maker destroyed it, intending to revoke it. So if that original is gone, we assume that it was intentionally destroyed. That's why a copy is not sufficient unless the court approves it. So make sure that the document you think is original has an original signature and you know where it is. So how do you know what you're looking for? Well, an original will, it's signed by the will maker, right? Signed at the bottom typically, usually is initialed on every page. Sometimes you can feel bumps on the other side and you'll actually know that it's original signature, but copies can be very tricky to decipher whether it's an original or a copy, so look really carefully at it. To be valid, the will maker must have made it in writing, So it can't be a video or audio recording. It has to be a document signed by the will maker in the presence of two witnesses. Those people can't be related to the beneficiaries, can't be beneficiaries, because that'll have the effect of voiding the gift to that beneficiary. So the identity of the witnesses is important. If any of these technical requirements are missing, there's a deficiency in some way, it might be possible for the court to validate that will. So if the executor brings it to the court can say, well, in all the circumstances, we consider this to be the last will despite the deficiency, and they would uphold it that way. Two other important pieces about a valid will is that it has to be made voluntarily by the will maker, and they have to understand what it is that they're doing and what the document says and the impacts of the document. So that's referring to the capacity, similar to that conversation about power of attorney. Will maker has to understand what they're signing, and they cannot be doing it as a result of someone twisting their arm or unduly influencing them to the point where they felt like they had no choice but to sign this will. If those circumstances are present, then that will be invalid and will be tossed out. So you think you have the original will, it names you, you have a choice to make. You don't have to act as executor. You can decline the role. However, you have to make a decision fairly quickly whether you're going to accept it or not, because you can't just sort of wade in and start doing things in the executor capacity and then decide it's too much for you and you want to walk away from the job. So you can't leave the job half undone. If you start to the point where you're considered to have intermeddled with the assets, that's when you can't turn around and hand this off to somebody else unless the court discharges you. So intermeddling really just means, have you dealt with the assets of the estate in some way? Have you used the deceased's assets, money, to pay bills, or have you given anything away that belongs to the deceased? If you've taken that role upon yourselves and acted in that way, then you've acted as executor. It's too late to resign easily unless you're discharged. Having said that, you can ask questions and you can investigate. If you want to get a better lay of the land so that you can make an informed choice about whether you want to act or not, you can do that to the extent that many third parties whom you're trying to talk to, they may not be willing to give you much information if you say, I'm not really sure if I'm going to be the executor or not. Most wills will have a chain of executors, a primary, an alternate, maybe even a third alternate. So hopefully there are other options if you're not willing to do the executor role. So right out of the gate, your first concern is going to be the funeral arrangements. And that typically is dealt with within, of course, a few days of passing. You do want to have the will at this point because it may say in there the deceased wishes about cremation or burial. So you do want to know what those wishes are. And then fairly quickly from that point on, the executor sort of has to launch into action for a few reasons. Firstly, because as quickly as possible, the executor wants to take steps to start safeguarding the assets of the estate. So do your reading through the file cabinet and potentially even the binder that the will maker left for you, because you need to identify and you need to investigate and identify what it is that the will maker owns, what their assets were, and what they owe, what their liabilities are. And you need to do things like check life insurance policies, check house insurance policies. Is the car properly insured? Make sure no one's driving the car. Rekey the house so that no one has unauthorized access. And these are your protective measures that you're taking to ensure that you and only you can be responsible for the assets in the estate until you're ready to distribute them. One of your handouts is in the package. You'll get a little bit more detail about that. This is the executor checklist. So this is quite a detailed resource, and you can follow through that. We've given you contact information, and some of the entities here may not apply to the estate that you're involved with, but it's meant to be kind of a comprehensive list. While you're working your way through this checklist, you will be notifying all the third parties that the death has occurred. So you'll need the death certificate from the funeral home, and you'll give that to the bank and the credit union and the insurance company. And you just start notifying all the third parties where the deceased had involvement of the passing. And this is important because we see lots of identity theft and identity fraud occur after death. So the sooner those institutions know that the person's passed away, the closer of an eye they're going to keep on things, and they'll lock accounts and they'll start have a little bit more oversight to hopefully catch any unauthorized access and use. And then probate. So the next topic we'll talk about is what is probate? When do we need it? Why do we need it? Not every estate, not every deceased person's estate requires probate. The purpose of probate, why we go through probate, is because it's required by a third party that holds the asset belonging to the deceased. They want the will to be probated because it confirms to them that this will is valid and the executor named in it has the authority to handle the estate assets. So if the executor goes through probate and is granted probate and then hands that document over to the third party like a bank and says, I'd like you to cash out the accounts now and I'd like all the money belonging to the deceased, the bank can safely follow that direction and safely turn over all that money. Even if a later will suddenly shows up and there's a different person altogether named as executor, the bank is still okay because they were following the grant of probate, saying that that executor had authority. So that's the reason why those third parties like a land title office and a bank are going to require that the executor probate that will to confirm its validity and confirm that they're the rightful person to have access. So how do you get probate? First of all, you're going to produce an inventory. So this is through the BC Supreme Court. You're going to produce an inventory for the court, telling the court what it is that flows through the estate and the approximate value, so that there's a total value for the estate size that the court's made aware of. You do have to notify the beneficiaries, and sometimes you have to notify people who aren't even named as beneficiaries in the will. So pursuant to the law, the beneficiaries are supposed to be given a copy of the will and a formal notice saying that the executor is applying for probate and the court registry that the executor is using. That's so that the beneficiary knows if they need to take some action and insert themselves into the process, and they've been notified what registry to use, and that the executor is undergoing the probate application. So all the beneficiaries have to be given notice, but if there's a disinherited beneficiary, a spouse or a child, they also have to be given notice. And that comes as a surprise to our clients frequently. So if a client makes a will and wants to disinherit the no good child, it's not the case that that child is never going to find out about it, that they've been left out of this will. In fact, the executor has an obligation to track down that person and give them a copy of the will, and that triggers their rights to contest the will, and we'll talk about that later. So the executor's job is identifying who actually is the beneficiary of the will. There might be class gifts like divide $100,000 between my spouse's nieces and nephews. The executor has to get out the family tree and identify who falls within that class gift, find them, give them the required documents. The executor is just giving them background information at this point. The executor won't know what it is they're entitled to. That will have to be determined as the estate moves along through the settlement. So that sort of packaged the inventory, the proof of notification, that goes to the court, BC Supreme Court. That's called your probate application. And that's what the court looks at, that along with the original will. The courts process it and issue a grant of probate. So this is an aside. This is to give you a bit more of a robust of the context. Not everything that the deceased owned at death has to go through probate, because not everything the deceased owned flows through the will. The executor's job and authority extends only to the assets flowing through the will. So there are things like certain types of investment accounts that won't go through the will at all. Any account, such as a TFSA or a RIF, that has a beneficiary attached to it, goes directly to that beneficiary. It doesn't go through the will, the executor doesn't have any authority over it, it's not disclosed in the probate process. So beneficiary assets could be life insurance, RSPs, RIFs, TFSAs, pension plans, segregated funds. These, if there is a beneficiary named, and sometimes there's not, but if there is, it has to flow outside of the estate. Also, anything that's owned jointly between the deceased person and someone who survives them. That surviving joint owner will take the asset for their own, presumably. Some of the benefits of that, for those assets that are falling outside of the estate, are that it's not available for the executor to use to pay out the debts of the deceased. So if the deceased had large liabilities, well, these assets that flow outside are not going to be subject to paying off those creditors. So that's a nice thing. Also, the will's variation context, this can be a good planning tool to mitigate that risk as well. And we'll talk about that in a minute. So that's what flows outside of the will, not within the executor's realm, not covered under the will. So just to really make this abundantly clear, if there are two spouses, the first one passes away and all of their assets are owned jointly or beneficiary designated, then there is going to be really very little job for that executor. There's not going to be any need for probate. All the assets are just going to go to the survivor spouse. That's a very simple, typical spousal situation. But on the death of the second spouse to die, we'll use Fred here again. So this is how the sort of analysis about probate would fly. We have Fred at death, let's assume, so he's the last to die. So he has bank accounts in his sole name because Susan was never added to the account. He has a RIF and TFSA that don't have beneficiaries, and he has his residence that's rented out. And these are all in his name and there's no beneficiaries attached. So we do know that yes, indeed, the executor, Susan, she's going to have to probate his estate. That's so that she can have access and control over this property and the funds within his account. There's enough money here that the bank certainly will definitely require probate. And we certainly know the Land Title Office always requires probate. So there we go. We're off into probate. Probate's not this terrible beast that everybody talks about and scares you away. Probate fees in British Columbia are 1.4%. They're a drop in the bucket compared to the capital gains tax that you'd be paying when you pass. And it gives the estate and the executor and the beneficiaries a well-established regime with legal protections along the way and obligations and expectations that everybody follows. So very nice, clear rules of the road. That's the benefit you have when your estate is passing through probate. I'm going to pause here and talk about what if there's no will. So this is where things can get very messy very quickly. This is a situation we would call this an intestacy. So an intestacy, there's no written will, there's no beneficiaries named, which means that the estate's going to pass on intestacy to the intestate heirs. So those established by law, by statute. There would be no executor in this case. There could still be assets that still have to be administered, but no one with any authority to do that. So the whole thing comes to a grinding halt, and it's not until the court appoints an administrator where someone can then be moving ahead with handling the administration. There's a pecking order for who can be appointed administrator. Starts with your spouse, goes to your children, any one of them, and then a little bit more remote than that. We see these kind of situations resulting in disputes between children occasionally about who should be the rightful executor administrator. And so that can result in some family strife. Easily avoided if there had been a will. Okay, so back to probate. We're in the probate process. We've filed our application. Through the courts, the court takes about 2 months, sometimes 3 to turn things around. And then they would essentially assess the probate fees at 1.4%. On $1 million in an estate, that's $14,000. That gets paid to the BC provincial government. And then the court will produce your grant of probate, which is your document that then allows the executor to control and get access to the assets. So with probate in hand, the executor is then going to be able to take over and get moving. So They're going to start liquidating, cashing in investments, basically selling what there is, pooling it all into one pot of money, making provision for debt, paying bills, determining any priority among any of those creditors so that those high priority creditors are paid first. They're going to be providing an accounting to beneficiaries. Tyson will talk about that in a minute. They will file all the tax returns for the deceased prior to death that are outstanding, and then for the estate itself, it has to have a tax return filed every year too, for as long as it exists and is earning an income, or there's assets that are being sold. So the executor will be engaging with a tax professional, usually an accountant, to help prepare all those returns. Finally, the last step in any estate is typically the tax clearance from CRA. So they'll issue a clearance certificate certifying that the estate, deceased and estate's tax affairs are clean, and that's the executor's protection that when they hand off the beneficiary, the inheritances to the beneficiaries, that the executor themselves don't have that personal liability anymore if there's a tax skeleton in the closet that comes forward. So the executor always wants that tax clearance. And then they can distribute to beneficiaries. Okay, so now we'll dig a little bit more into some of the roles of the executors, and my partner Tyson will talk to you about accounting.
Thanks, Leah. So I was in court for a big chunk of the day, and Leah told me she changed some of the slides. So this would be a surprise for me, maybe as much as for you. What comes next?
You got it, Tyson.
So accounting to beneficiaries. So Leah kind of gave you a very summary of the estate administration process, and the accounting to the beneficiaries is one of the last steps, sometimes the last step. And essentially the slide spells it out here. The executors have to give this accounting every 2 years, or of course when they want to wrap things up. And so it's every 2 years if the estate lasts longer than that. So the general approach that most executors should take, and that we take with our clients when we're doing estate administration for them, is that the first step is sort of an informal accounting to the beneficiaries rather than the more complicated court forms that are used. So it might be as simple as a spreadsheet, a table, setting out, and what it's got to set out is, here's the assets that were in the estate when I took over, when the person died. Here's the income that's been earned on them. Here's the expenses that have been paid. So here's what's left, and this is how I propose to distribute it. And if it's got all that information in it and you get the beneficiary to say yeah and sign off on it, then you're good to go. In the cases where the beneficiaries can't sign off or won't sign off, then you may have to go past those accounts before the court, and then you need the more complicated, longer court forms that are, again, the court has a particular form they want to see these accountings in. Fortunately, that doesn't happen very often. Usually the beneficiaries consent right away. Sometimes you have to sort of finagle them to get them to do it. But the whole point of this process is to make sure that the beneficiaries have signed off on what the executor has done. And what I often tell clients, beneficiaries who call me and say, you know, my brother's the executor and I haven't heard from him in years and I don't know what's going on. I feel totally in the dark and I have no power in this process. And what I tell them often is, you're right, your power is really backloaded. So the executor kind of has all this authority up front, and the beneficiary's power comes in at the end when they have the right to see these accounts and approve these accounts. Now, some people, executors who don't use a lawyer, don't get legal advice, don't realize they need to do this. And so all of a sudden one day you just get a check with no accounting, no consent form. You have no idea where this number came from, whether it represents your proper share of the estate. And sometimes that's when people come and hire us as well, as to say, I don't know what's going on here. I don't know how to ask questions. And so there's a whole process for beneficiaries to do that. In the accounting stage, in the case of a beneficiary that won't consent, is almost like a negotiation where you're getting information, trying to figure out what's fair, and going from there. The accounting really is a reflection of this, the executor's legal duty. And it's the exact same one that Taylor talked about with respect to powers of attorney. It's a fiduciary duty, and the fiduciary duty comes from Latin, right? Fidelity is another word that we use in English that comes from the same root word. It means trust and good faith and all those kinds of things. So it's the highest duty that we have in law. You have to essentially disregard your own interests. you take over as an executor and there's all this money that needs to be invested because you have to wait a year to pay taxes or whatever. You might think, well, I've got this great business venture and it could make the estate 10%, way more than the market. And you can't invest in your own company, your spouse's company, your kids. You really have to be completely selfless and really disengaged with respect to your personal interests. And you have to be completely transparent. And this is where the people I was talking about before, the beneficiaries that come in and hire us when it's been years and they haven't heard anything. This is what those executives have forgotten is, yes, there's a lot of authority, but on the flip side, you have to be totally transparent. And in fact, the law says you have to be ready to account basically at any time. If the beneficiary shows up and says, I want an accounting for the estate, you should be able to get one to them in a short period of time. So you have to keep those records and make sure you're ready to do that. Obviously, acting in accordance with the will and the applicable law, avoiding conflicts of interest, and that's what I was getting at before. And this is where executors sometimes fall down on the job. They want to sell a property to themselves. They want to hire their son to mow the lawn for $100 an hour. I've seen a lot of these kind of situations that where it's either our client asking us that, we're going, no, 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 or it's a beneficiary coming and saying, I got these accounts and I can't believe how much they paid for this. And you're like, well, yeah, okay, I see what happened here. Somebody wanted to get their son a summer job and make a lot of money. To whom are the executors responsible? So beneficiaries of the estate, this is what I was talking about, that backloaded power. The primary responsibility of the executor is to the beneficiaries. And again, this is what's usually satisfied with respect to this accounting process at the end. And often we recommend that our clients make disclosure before the accounting process, sometimes get input and get consent from the beneficiaries even before the accounting process. And this is especially with respect to big decisions about big assets. Do we want to let, there's a situation with multiple beneficiaries. One of them really wants to buy the estate property. Maybe it's a cabin, maybe it's the house. Even if, the executor can do all sorts of steps to make sure they're getting the right value for it, go get an appraisal, those sorts of things. But the best thing to do is tell all the other beneficiaries, this is what this person was proposing to do. Here's why we think it's fair market value. It's in the best interest, but I want to make sure that you guys are okay with it. So please, please approve it. That's the best practice in these sort of processes. Executors also owe duties to creditors of the estate. Creditors generally have priority for most things over particularly what we call the residual beneficiaries, the beneficiaries of whatever's left. The creditors have priority over them. So there's duties owed to creditors and duties owed to avoid favoring one creditor over others. And that's actually a file that I recently had that we just sort of wrapped up, was one where that was essentially what we were complaining about, was that the executor, the deceased and his wife had separated before he passed away, and the executor was essentially favoring the wife's creditor claim, essentially paying her more than what we thought the claim was worth, with the idea that most of her estate was going to flow to him and not the other beneficiary. So it was kind of a little bit of dirty dealing there. So we were very stringent on making sure we had oversight over what was happening with that family law action to make sure it was done properly and that she wasn't favored unduly. Executor liabilities. Obviously, we're talking about this super high duty of executors. It means the executors are held to a very high standard. There can be personal liability for loss caused by any sort of misconduct, and that includes deliberate misconduct as well as negligent or careless misconduct, and everything in between. So those things I was talking about with the conflict of interest, maybe that's not deliberate misconduct. I didn't intend to lose the estate any money, but you make a bad investment that you had a conflict of interest in, you may be on the hook for that, any loss that results from that. And the example given there, failing to get insurance for an estate property. This is a good example of when you're writing your will and you're naming your executor, make sure you name someone who's going to check. That really the punctual person in your life who's always crossing the T's and dotting the I's, that's the person you want as executor, because you want to make sure it's someone who's going to look at the fire insurance policy. Wait a second, that expires in a month. I better get on this. And not the person who says, oh, great, there's fire insurance, and turns it over and doesn't look at it anymore. Executor compensation. So being executor can be a lot of work. It usually is a lot of work. Sometimes it can be a very daunting amount of work. And executors are entitled to remuneration, to a fee. The biggest fee, the main fee, is capped at 5% of the value of the estate assets. And that's reserved for the cases where the executor has to do the most work. And generally, the example I give people is if the person dies and they have an operating sole proprietorship business and the executor has to step in and run that business from day one, that's kind of like the gold standard of an executive that has to be doing a lot of work. But there's other situations where that comes up too. Really complicated ones that Leah sees all the time, cross-border estates, where the executor's got to consult with multiple different accountants in different jurisdictions and lawyers in different jurisdictions and figure these things out. Those can require a lot of work as well. Generally, we kind of tell our clients 2 to 3% is a more likely fee that might be obtained for a more regular kind of estate. This compensation is generally rolled into the accounting process. So the accounts will also often include a line item for the executor's fee with a percentage and a number that's worked out from there. And again, as part of that process where the beneficiaries get to review the accounts, maybe they find some sort of imprudent activities or wrongdoing or whatever, they might say, okay, well, your fee was going to be $25,000, but it looks like you cost the estate $5,000 here, so we're going to knock that down to $20,000. And there's often that sort of horse trading that goes on between the beneficiaries and the executor there. Can executors get help? As I said, in many cases, it's a very complicated, difficult, time-consuming job. And it would be really ridiculous if we just expected people to be good at it. Most people have maybe done one little slice of this job in their life before, but not the whole thing. And so executors are allowed to and encouraged to hire professionals to help them. So I mentioned appraisal, property appraisal, make sure you're getting the right amount for the property. Investment advisors to make sure the money is invested prudently. Realtors, obviously, if you're going to sell the property, you shouldn't try and do it on your own. Estate lawyers to help you prepare the probate forms, consult with the beneficiaries, particularly in a contested one or a complicated one like we've been talking about. Accountants to do the tax returns. So there's always multiple tax returns that are required. There can be a lot of ins and outs. Sometimes they're fairly simple, but a lot of times there's lots of ins and outs. And there's trust companies that will help for a lot of the other things, even like inventorying the house of assets or the cabin or the storage unit or whatever. They can help there as well, and they can provide, again, for an executor who might be very emotional, loss of a loved one, overwhelmed with all this work, hiring some of these professionals can really help. And it's good to know that the fees paid to those professionals, it's not like it comes off the executor's fee, but obviously if the executor is doing less work because they farm more work out, then they're generally entitled to a lower fee than they would be if they'd done it all themselves and save the estate that money. So there's a bit of a balance there, but it doesn't deprive you, if you hire an accountant and a lawyer and an appraiser, it doesn't deprive you of the ability to ask for a fee. And the biggest thing here is not only avoiding the stress and everything of doing all this work, but the liability as well. Lots of the files that come across my desk involve, they sold this property for some crazy price. It was ridiculously low. They didn't use a realtor, or they didn't get an appraiser, or the estate had to pay $30,000 in back taxes because they hired, a crappy person who didn't know how to do their taxes to do the taxes. They tried to do it themselves. So avoid that liability. If there's any complications at all, reach out to the right people for help. So this is the kind of things that lawyers can help with. Another reason when to hire an estate lawyer, one of the big things is avoiding having that neutral voice to avoid you making the emotional decision. And it's really striking to me. I've had lots of clients who are professionals, accountants and retired engineers and doctors and stuff like that. This stuff makes them emotional, much more than they would ever be in their professional lives, and more than they would admit or even see themselves. So it's good to have a neutral person, whether that's a lawyer, in some cases an accountant or whatever, a trust company, to help you make some of these decisions. I'll give you an example of a file I had when I was just starting off, where it was a file about the misuse of a power of attorney. The lady had died, and my client took over as executor, and they found that the sister who'd been acting as power of attorney had taken a bunch of money. And so we had a lawsuit about it. We ended up in a negotiation, and my client and her brother, who were the other two beneficiaries, we were very close to a deal, and it almost fell apart because they started talking about how and they were in their 70s, about how their sister, who was on the other side, she'd always gotten in her way since she was 6 years old, and we're not going to let her do it again. It's, guys, we're talking about stuff that happened 6 decades ago. Like, is this really worth it? But those are the kind of, and that's the kind of things I see a lot. There's a bit of wanting to punish someone for something that they did a long time ago, or that, you know, not visiting mom enough when she was in the hospital bed or whatever. And having this sober second voice can really help avoid those kind of issues. Accountants, as I mentioned, taxes are a very important concern. Again, multiple tax returns are going to have to be done, and you want to hire an accountant that's experienced with estate taxes for sure. Trust companies is another one I mentioned, used primarily for larger estates, but essentially executors are able to shift almost as much work as they'd like to a trust company, because trust companies will also act as your executor. They're sort of primed to do the whole job, and they can also do parts of it. So definitely can be worthwhile, especially if you live a long way from where the person's passed away and there's a bunch of things to inventory and deal with that way. Trust companies can help for sure with those things. Of course, the executor always has to make all these decisions, right? The lawyer, accountants, and trust companies can give you advice and help you, but the big decisions still have to be made by the executor. So that's the presentation. So we're, like Leah said, we're open for a Q&A. If people have questions or things that have popped up while we were talking, there's lots of materials for a handout. I see a question already. There you go, sir. Yes, and normally that's the way it's done. There are some cases, you know, you may have a reason to appoint a power of attorney who's closer, more physical proximity to you, that's able to go to your bank more easily and that sort of thing. But usually it's, you know, because it's the same sort of role. It's a person you trust to make these kind of legal and financial decisions and keep things organized. So it's the same sort of role. It can be more than one. It usually is just one. Once you start getting into multiple executors, especially more than two, then you create problems because there's some forms that all of them have to sign. For instance, Leah, correct me if I'm wrong, the land title forms have to be signed by every executor. So if you name 5 people, this form has to be passed around to 5 different people who've got to sign before, you know, all before a notary or a lawyer. So it can get pretty complicated. Usually people stick with one, but sometimes you see 2 or 3. Mm-hmm. So if there's an alternate in the will, so sometimes the will will say, I appoint so-and-so. If he or she is unable to act, I appoint so-and-so. That's obviously the next person. If you run through that chain, you don't have anybody left, then it's essentially there's no effective executor appointment. And it was what Leah was talking about before about the administration in the case of not having a will at all. So there's essentially sort of a rough priority list about who's able to apply and who would have priority if multiple people applied. So you do want to think of a couple alternates for that situation, because again, it's not a good situation to leave people in when everyone's got to sit around and say, who wants to do this job? Or what's worse is if 2 or 3 people who don't like each other all want to do it, and then they'll end up hiring someone like me, and the whole estate gets spent fighting in court about who should be in charge.
I just want to jump in with one comment there. Taylor was just mentioning that this is a role sometimes for a professional executor like a trust company is sometimes a good choice where there is conflict among who the other executors might be. So if there's 3 or 4 or 5 children and the parent can't choose among them or doesn't want to have to choose and doesn't want to name all of them, they might start looking outside to another third party, friend or family member. And a trust company like a bank associated with a bank, they can be appointed as executors. So they offer that neutrality, that arm's length. That's sometimes a good choice for some people. It's different based on the registry, but that's mostly to do with staffing levels. So in Vancouver, they might process applications in 3 or 4 months, and we do it in half the time. And Prince George will do it in a different time frame. But it's rarely a year or more. That would be highly unusual. You know, you're expecting it's you can use any jurisdiction in any registry in the province. Matter of fact, yeah.
So there's some people that really chase them. They figure out, Williams Lake is really quick these days, and they file everything in Williams Lake. But what you're talking about with the probate taking a year, there may be a little discrepancy in what we're talking about here. Leah's talking about the 48 weeks is from the moment you file the paperwork with the court until they get back to you. Some people, they say probate took 2 years. They may have spent a year and a half getting all the information they needed in order to file it. So that may just talking about different things. It doesn't matter where it's written as long as it meets BC's criteria. So the problem is that some other provinces have slightly different criteria for what makes a valid will. So in BC, like I think Leah was talking about, it has to be signed by the will maker in the presence of 2 other people who then sign as witnesses. But in some other provinces, you can have a will that's only signed by 1 person as a witness, for instance. So it doesn't matter where it's done. You can make a valid will in China or Australia, but as long as it meets those BC standards for validity. Yeah. Sounds like a TV show. You have to walk up to their house and you're disinherited. No, it's you have to mail a notice out. And if you don't know their address, you have to make reasonable efforts to try and get the address.
And usually that's done by your lawyer. So in fact,
it's a letter from Leah that says,
you don't want to be poking the bear. You don't personally have to do it.
And I've seen Leah's letters and they're very nice. They don't actually say you're disinherited. They just say, here's a copy of the will. Yeah. Go ahead.
Executor. Yeah, it goes along with that notice.
So what can happen, and I've had a couple of those situations, is that the whole grant of probate can be tossed out. Yeah, a lot of things can happen. Yeah, that sounds like the kind of thing that I would be dealing with. Yeah, I mean, a number of things can happen from there. The beneficiaries, I mean, it'd be kind of, you'd almost do it backwards, right? You'd say, okay, well, executor, thanks for the check. Where I need some kind of accounting to figure out whether that's the right amount of money or not. And you try and drag that out of them, and then you go back a step and say, if that didn't satisfy your concerns, and say, okay, well, why didn't I get notice? Who else didn't get notice? And so that's the way I would conceive of doing that, but there'd be all sorts of different ways to get at it depending on exactly what the circumstances.
And if you cash the check?
Everyone thinks you shouldn't. I always say go ahead. They haven't asked you because this is the reason why we're talking about this consent. At the end of the day, consent to sign off on what the executor's done. If you don't have that, and the executor just shows up in court and says, well, they cashed the check. I thought they were fine with it. Good luck for a judge with that one. Because the judge is going to say, well, you're dummy. You sent them a check without getting them to sign off on it. Mm-hmm. They haven't discharged you from anything. And the normal process is to get them to explicitly discharge you. I haven't seen the case where that's come up, but I would not want to be on that side of it. I would want to be on the other side saying, no, I didn't discharge you of anything just by cashing the check.
If that executor is not forthcoming and you say, I want to see the executor accounts and I want to see your explanation and how you've handled the estate, and you're just getting nothing but radio silence, there's a process where you can force the executor to bring their accounts in front of the court. And then there's ramifications if they don't do that properly, and they have to use a particular form. So it's forcing them to do it at a certain standard and level of standard. So Tyson's done that many times where he's had to force executors to, pass accounts. That gives you the beneficiaries the disclosure they've been looking for.
And that's part of what Lee was getting at with having your estate go to probate is not a bad thing, because it does force this disclosure process of, okay, he's sending out the notice to all the beneficiaries, here's the will. and then filing the stuff with the court and then getting the grant. Like there's all this paper trail. If you have an estate that doesn't require probate, let's say it was, a bunch of money, $200,000 that was just in a joint account, and that's the whole estate, and it's a joint account with one of the siblings, and mom says, yeah, split it with everybody. That sibling can take as long as they want. The other siblings don't know what's going on. There's no court file open, so there's no easy avenue for those siblings to bring a challenge and say, I don't know what's happening or whatever. So there are some advantages to probate. It's not really that expensive in the long run, and there's some predictability advantages to it.
One of the things I alluded to, but I realized it's a different presentation. We don't have a slide on this, but it's contesting the will. And that reminds me.
Oh yeah, Leah kept promising that I was going to talk about that. And I was like, I don't think that slide's in this presentation.
You got to fix that. But do you want to give them a...
Yeah, so so there's a number of different ways to contest a will. The sort of one that people tend to think of the most is what we call the validity challenge, right? That, the will maker didn't have capacity, didn't understand what they were doing when they signed it, or someone had a gun to their head, which is what Leah was talking about. They twisted their arm into signing it, right? So that's one way to challenge a will. In BC, we have special legislation that some of you probably heard tell of called wills variation that allows you to challenge a will on the grounds only that it's unfair. So, and it's only for children and spouses of the deceased person. So that's another sort of challenge. That's probably the more common one in BC because it's so broad. You don't have to claim that the will is invalid or the person had a gun to their head. You just say, this is not fair to me for X, Y, or Z reason. So those challenges, in particular the variation challenge, has a 6-month limitation period, but it doesn't start until the date that probate is granted. So if you have a will that doesn't require probate, in theory, the limitation period never starts and never ends. So you could be, in theory, again, I haven't seen it done, but you could be 10 years down the road, and all of a sudden, the sister that no one's seen in years pops out of the woodwork and brings a wills variation challenge. So that's another advantage of probate is it triggers this formal process that has these things built into it that make everything more predictable and give you that finality. Yeah.
There is no actual dollar value for probate. So it's actually at the discretion of the third-party entity that controls the asset. So if there's $5,000 at a credit union and $50,000 at the Royal Bank, the Royal Bank will say, we're not letting $50,000 out the door to that executor unless they get probate. The credit union, though, their exposure is only $5,000. They might say, we don't really care about probate or not. We're comfortable handing over this money. Here you go. So it's really determined on an asset by asset basis based on the comfort level of the institution. And when I said that land title office always requires probate, doesn't matter if the land value is $1 or $5 million. You have to have probate to process anything through the land title office. It's a common misunderstanding. People think, oh, estates under $25,000 don't require probate. No, that's just false. It's just not true.
Probate's like the way I think of it. It's like a code or like a key.
It's
right?
a key, magic key.
To get the magic key to get into that bank account or that land or whatever that the institution's going to make you get in certain situations. So what you're talking about with the dollar value, what the estates we're talking about that don't require probate, there's no limit on their dollar value. The reason they don't require probate is because of the way the assets are held. So let's say right before you passed away, you went and put all your money into buying Picassos, right? The Picassos are in your house. Conceivably, your beneficiaries come and take one each, and your estate's distributed. So no probate was ever required. Now, I don't know anything about fine arts, so maybe there's some registry that you're supposed to buy your Picasso in. But that's the kind of situation where probate wouldn't be required. Or if you had all your money in a joint account and you put your kids on as joint owners of it, right? Or one of your kids as joint owners. So that's an estate that wouldn't require probate because there's no institution that's going to make you have the key. Once your name's on joint, the institution has to let it go, barring other things. But on its face, they just have to let you take it. I think you had the next question. Yes.
Always.
Happens all the time. Yeah. There are limitations on what the powers of attorney can do. The banks, if they're watching, shouldn't let them transfer assets to themselves. The land title office certainly is not supposed to let them transfer assets to themselves, but it happens. And there's no oversight. There's no other than the PGT, which only becomes involved in very particular circumstances. And there's no police watching over them. And sometimes that's very surprising to people that say, well, that's illegal. How can they do that? Well, nobody stopped them. And so it's up to the other people who stand to benefit to pursue their sort of private law remedy against the person who did the wrong, right? So
sometimes it comes up in the hands of the executor. So power of attorney Jack does their thing, person passes away, and executor Mary starts auditing what power of attorney did. And then they can hold that person accountable on behalf of the estate. Sometimes that's a nice reason to have two different people. One person as POA, one person as executor.
yeah, if you only know shady people and you don't entirely trust any of them, pick two different ones.
Yeah, right? Worst of the worst.
Where it comes up even more, and it's stickier than the situation Leah talked about, is where it is the same person. And they've been power of attorney for 10 years, and now they're executor. And the beneficiaries don't see anything until 5 years after death when they get an accounting. And they go, what? How did dad only have that much money? Like, what was happening? And then you're asking for bank records from 15 years ago. No one's got them. I had one terrible one where everything was intermingled. Like, I think this person, if he tried, he could not have intermingled the bank accounts more. Everything had money coming in from both persons, going out to both people. It was just an absolute nightmare to try and sort out what exactly had happened and where the money went. So yeah, it can be bad. I mean, I say it happens all the time. It doesn't really happen that often in the grand scheme of things. I see it all the time because that's what I do. But yeah.
Right. I think I got three parts to your question. And I might have forgotten the first one already. If you do probate and there are assets flowing outside of the estate to a beneficiary who's not named in the will, you do not have to give that beneficiary a copy of the will because they're getting something outside of the estate, and what the will says means nothing to them. It's none of their business.
Unless they're an intestate successor.
That's right. Yeah. So if they are a spouse or a child, that drags them back in and they have all these rights to contest the will. So now they have to know what's in the will, right? If you're not probating the estate, so the requirement to notify the beneficiaries is triggered because you're going through the probate process. To get your grant, you have to notify. So if you're not going through probate, there is no statutory requirement to provide any notice to any beneficiary under the will. However, there's common law obligations to at least let the beneficiary know what the will, portion of the will affecting them says, so that they can have adequate disclosure to understand what their expectations and rights are. So it's kind of a half answer for that second situation. It's inherited, yeah. No, don't have to.
Yeah, there's no statutory requirement. There's a lot of gray area in this spread of the law. I mean, often have people come and say, well, don't they have to give me the will now or then or what time? And there's no real straightforward, like, black and white answer about that kind of, like, the kind of situation you're talking about, where there's no probate and the assets are small and they're not getting anything. The common law requirement, I think, would only extend to people who are actually getting something in the will. The people who aren't getting anything are only included because the statute forces us to include them, so that we can trigger these limitation periods. Yeah.
So if we were acting for a beneficiary who thought they'd been left out of the will and they'd never been provided a copy of it, we could start an action, start a lawsuit, and force the executor to give us a copy. Right. Back door way.
So they might say, well, what you want title to the house, you actually were holding beneficiary. So it might come out in the wash.
Mm-hmm. There's lots of opportunity.
Yeah.
And this is a
Yeah.
whole other presentation, and it's fascinating.
Yeah.
I know.
Yeah.
Yeah. Yeah.
Yeah. I like to leave people with this like very upsetting thought, that the legal presumption, that is presumption that courts apply in those situations where someone's gratuitously added as a joint tenant on a bank account, for instance, or a property, is the opposite assumption that the banks apply, right? The banks look at it and say, oh yeah, you're the surviving joint owner, here's the money. And the law actually says the opposite. The courts say, unless you prove to me that the person intended for you to have it, you are not the owner and it's part of their estate. So it's a big mismatch between how the banks deal with it. And I'm slowly seeing the banks get slightly better at it. In fact, a couple of the credit unions are quite good at it now. Their forms are much more detailed when they're asking someone, okay, you want to open a joint account. What do you want to happen to the money when you die? Is it going to your estate? Is it going to the person that you've put on as joint tenant? Making that more clear, because it's a big disconnect between the way that institutions operate and the law. Yeah.
Right.
Yeah.
Till all the liabilities and creditors have been
Yeah.
paid.
Yeah.
Exactly. Precisely.
It's where you don't have probate. It's a fly by night sort of thing, right?
Yeah. Stepchildren don't have the rights to contest their step-parents' will.
Yeah, and a bit of a disconnect there because they have rights in family law, but not in estate law. And the reason for the distinction is because they would still have rights against their biological parents' estates unless they're adopted away from this parent to this parent, right? So it's essentially the estate law says, wait a second, you're not allowed to have like multiple sets of parents that you can all draw from their estates. Yeah.
And in fact, siblings cannot contest a will at all. So if the
For variation, they
For
can't
variation.
apply to vary a will.
That's right. They can't say this will is unfair. I'm a sibling and I was left out of it. They have no standing. It's only spouses and children who can say the will is unfair to me.
Yeah. Siblings could challenge for other reasons, like let's say you were provided for in your brother's will and then he changed on his deathbed to leave it all to his caregiver. You could challenge that last will for being invalid, right? That the caregiver forced him to, or unduly influenced him to, or he didn't understand it, or whatever.
Once 6 months
6
elapses.
months from the date of probate. Yeah. Yeah. Yeah.
Good question.
Yeah, it'll be taken into consideration, like everything else that the court would. It would come up to court in a trial, and the judge would see it. But again, the court is allowed to vary the will. So a statement that says, "Well, I really don't want this person to get any," doesn't have a lot of weight. It's where if it presents a really good reason, right? And the best one I always have is, my estate's worth $500,000. I have 2 kids. I gave one kid $500,000 already, so I'm going to leave everything to this kid. That's sort of the ultimate explanation for this inheritance is probably going to hold water. Where there's an estrangement that it can fairly be said is entirely or almost entirely the fault of the child. A disinheritance might be justified, but almost anything short of that, they're going to get something. It might be a smaller share than their siblings, but they're probably going to get something. And there's often 2 sides to every story. And with respect to those kind of statements, they can sometimes be a bit of a double-edged sword because the tendency of the person writing it is to exaggerate how badly they've been treated. And if that's factually untrue, if they exaggerate to the point that it's untrue, and you see people saying, I haven't seen him in 20 years, and the kid can prove that he saw dad, every 3 or 4 years, well, then the court's can say, well, what weight can I put on this at all? The person's lying. They just don't like this kid. So it can be a bit of a double-edged sword. It has to be very carefully written out and explained. Like financial, like the executor's giving the information.
To the executor's lawyer? Yeah, the state's lawyer is the executor's lawyer because the executor hires that lawyer. And you can't get any response out of your law firm? Oh dear. Phone a different law firm? Yeah, that's a tricky one. Try to run it up the chain somehow?
Yeah, I don't know.
Yeah.
Depends on the situation, I guess, how you would deal with it. But certainly you'd want to, keep following up to the point where it became obvious that they didn't want your file anymore before you tried to move on, I think.
Mm-hmm. Very good question. No, that seems to be unusual. I don't want to say anything disparaging about my fellow lawyers in the city, so I think we'll keep our comments to a minimum, but that would be unusual. Not necessarily. No, you can make a will in contemplation of your marriage. If you split up, you're going to need to revise your will, right? But you don't have to wait for the marriage certificate or a change of name before you can do a will. That's absolutely right. Yeah. Mm-hmm. Good. Did we get everybody's curiosity? Good.
Thank you.
Well, thank you.
Thank you.
All right. Well, thanks everyone for coming. That was great. 8 o'clock, right on the money.
What's that?
Right on the money, 8 o'clock.
Yeah. My fuzzy slipper fell off here again. Doesn't look like a little pom-pom on someone's